Today we're going to discuss about the exciting topic that the immigration provisions have been passed in the House subcommittee, Judiciary Subcommittee. And we're going to discuss about how this bill is going to affect the employment-based immigration, how this budget reconciliation bill is going to be beneficial for the employment-based immigration. We're going to discuss about the October visa bulletin, what is expected in the future. We're going to also discuss about if you are in adjustment of status and if you want to change to a different company, what are the steps you need to do for that? Now, Emily, coming to the point on the main thing of the Judiciary Committee passing by 25 vote to 19 vote. This is a very record event that happened. So explain this, Emily. What are the steps that are needed? What are the steps that are needed for this one to become a law?
Yeah, so this, if you remember, we've talked about before, this is part of the budget reconciliation process. So we already have a budget framework, that's the $3.5 trillion. That gave the directive to the House and Senate committees to come up with legislation that will implement that budget by explaining what changes needed to be made to existing legislation to make that budget effective. So that's where we are right now. So all of the different committees are doing the same thing right now with various provisions that are going to be part of the budget. So our little part is just this tiny 17-page immigration section, but the overall budget bill is going to be huge. So this section, the immigration provision, did go through markup in the committee yesterday. They had a lot of debates on it. Republicans were trying to add amendment after amendment to change everything about the bill. All of those amendments were blocked, and the Judiciary Committee approved this version of the bill that we've shared with you previously. Next step, the bill has to be debated on the House floor. We're expecting that to happen sometime next week. At the same time, the same process has to go on in the Senate, and that really hasn't gotten started yet. We don't have the Senate's version of the bill. The Senate still has to make sure that their parliamentarian is going to agree that immigration reforms can be done through this budget reconciliation process. So we get the House version finalized hopefully next week. We get the Senate to agree that it can be done, and then they finalize theirs. Any differences between the two have to be worked out in a final bill. Then that goes to the president for actual passage into law.
So, Emily, what are the contents on this one, especially when it comes to the employment-based immigration? What are the contents on this one, on the bill that's going to benefit the business immigration people?
Yeah, we do have a couple of major improvements to the immigration process for employment-based applicants. Number one is going to be the recapture of green cards that have gone wasted, going all the way back to 1992 through the current fiscal year 2021. So we've talked to you guys again and again about how CIS is so slow in processing adjustment of status applications this year that about 80,000 are expected to go to waste at the end of this month on September 30th. This bill prevents that, and on top of it, it goes all the way back to 1992 and recaptures every employment-based green card that went wasted and makes it available now. On top of that, going forward, it stops them from being wasted so that any unused green cards next year will fall over into the following year. At the same time, it does this for the family-based category too, which means that going forward, we won't see that same spillover of unused family-based green cards from one year going into the employment-based of the next year, but at least we'll make sure that employment-based are not being wasted.
According to the estimates, approximately about 300,000 green cards will be added to the employment-based green cards, though. If this bill goes through, so 225,000 are expected wasted between 1992 to 2020, and in 2021, that is ending in October, we're expecting about 60 to 80,000 green cards to be wasted. So approximately around 300,000 green cards will be coming into next year. So, and if by any chance they are not used, though, they will not be wasted, they will go to the next year. So we may expect a drastic movement in the priority date all the way to 2019, or that's my expectation if this bill moves through. Emily, is that it, or is there any other better provisions that are there in this bill though?
Yes, there's an even bigger provision that is extremely beneficial for those that have been stuck in the backlog for years. This allows anyone who has a priority date that is at least 2 years old to be able to file a waiver application, pay an extra $5,000, and be exempt from the employment-based green card numbers. That means you can skip the line completely by paying $5,000 and receive your green card even though a green card is not actually available to you. And this provision would take effect beginning as early as May 2022. So that basically means that May 2020, anyone who has a labor certification filed before May 2020 should be able to file their adjustment of status in May of 2022.
Voila! That's going to decrease the number of people who have been waiting for the green card for so long. So, Emily, is there any hiccup to it? It seems that too easy. I mean, $5,000, believe me, I know we had a debate in our office. Our lawyers were reluctant in supporting it for $5,000. Then I convinced all of you guys, a lot of the people who have been waiting, they will not hesitate in paying the $5,000. And then we did a TV show on Monday. It's been clearly proven that, no, we don't care about $5,000. It's been clearly proven that they don't care about $5,000. At least 98% of the people will not care about the $2,000. So if this bill passes through, if the priority date is May 1st of 2020, they can file the adjustment of status on May 2nd of 2022, which is just 7-8 months from now. Is there any catch? Is there any requirement that they must be present here? Because I saw some of the provisions in the bill that they must be present here on January 31st of 2021. They must be residing from the past 3 years.
Yeah, now there are a lot of different things all rolled into this bill, but this section stands by itself. So those other provisions that are related to being physically present January 2021 and having 3 years continuous residence and all of those things does not apply to this section. You need a labor certification approval that has a priority date that's at least 2 years old, an I-140 approval, and be in the U.S. at the time to file your adjustment of status. And of course, your employer that sponsored you has to be supporting you in filing that adjustment of status.
Are there any other provisions in this, Emily? We were discussing about the Dreamers, which were been told that that the Dreamers will be included in this bill, and at that point of time, the Dreamers were being given the employment authorization, but those people who maintain the legal status were not being given employment authorization. So, what about this bill? Does it cover the people who maintain the legal status also?
Right, so there's not a specific provision for the legal dreamers, the kids aging out, but you are covered under the dreamers section. So there are multiple other sections in this bill. One would provide relief for undocumented dreamers. Another is for those that hold TPS, DED, and then the critical infrastructure essential workers category. So the great thing about this bill is they did not limit it to only people who are undocumented. So that means legal dreamers who may not before have been able to get employment authorization like the DACA kids can qualify. But this does have some requirements of you have to be physically in the U.S. from January 1st, 2021, and you do have to have entered the U.S. before you were 18 and have 3 years of residence in the U.S. in order to qualify. It does not require an employer sponsor. So as long as you meet those requirements and have gone to school and either graduated or done at least 2 years in a program or had 3 years of income, then you can qualify for this even if you are legally in the U.S.
It's either college degree or high school degree or 3 years of income in United States must be coming into United States before you're 18. you must be physically present here on January 1st or January 31st of 2020.
January 1st.
January 1st of 2021, and you must not have left. So all those people who are planning to leave the country after January 1st of 2021, I mean, are you planning to have any of your kids leave for vacation? They may be out, because if they leave the country, they may not be eligible. So if they have any plans to leave outside the country, if I were them, I would not let them leave. Wait until how the things will go on before they can leave. So legal dreamers and also people who are not, maintaining their status, both are covered in it. We've been fighting for so long. This probably will cover the age-out kids also, for those people who came in with the parents. Parents got the green card, or parents are adjustment of status, but the children were unable to get in. This is a very perfect role. So I recommend all the people who believe that this bill will help people should write letter to the congressman. Our senators, we have put a sample letter at the bottom of it. Please, if you think so that this will help you or any of your family friends, try to have this one recommended and write a letter to the congressman. Emily, there is also provisions with regards to the critical essential workers, though. According to the law, what I see in this 17-18 page law, what it says is that if they were critical, if there are essential critical employees, and they were being employed between January 1st of 2020 to August 24 of 2021 in those essentially critical employment. And they are present here in January 1st of 2021, they can also file the adjustment of status. Do they need, if they are essential critical workers, do they need any employer? Do they need a labor certification I-140 approval?
No, this seems to be very similar to the provision for the Dreamers, and it also does not require any sponsorship, but they do have to have worked as a essential critical infrastructure worker during the COVID time period, which they've specifically set from January 2020 to August 2021. And they haven't set out in the bill what qualifies as critical infrastructure work, but they do refer to a memo that has a list of 14 different categories. This includes your healthcare, your law enforcement. It includes communications and IT, chemical, and a couple other things. But it's not very specific what exactly will qualify. And there's a very good likelihood that the Biden administration will look at this very broadly and interpret it broadly to allow more people to qualify under this critical worker section, rather than defining it very narrowly, where they could almost make very few people qualify.
So let me tell an example of it. If I am a OPT student, and if I have worked, or OPT and STEM extension, if I have worked with a company like Pfizer, did some programming for them to help this vaccines distribution or so, I don't need any employer to file a labor and I-140. I can file adjustment of status.
Right, as long as you were physically present January 1st, 2021, and you worked during those the COVID times and were physically present in the U.S. for 3 years.
And you must not have left the country after January 1st of 2021. That's a very critical thing for you guys. So if you fall into any of these criteria, if you're planning to leave, you may not qualify for filing the adjustment of status. When I read the memo that has been pointed out in the law, though, Emily, it does point out to a lot of different things. Other than the communication and information technology, they also point out to financial services. They also point out to the energy sector, water and waste management, a lot of different food and agriculture. There are a lot of things that are covered in this one, though. So it's very broadly interpreted according to what it is, what I read it. If you're telling that Biden administration is going to broadly interpret, this may be heaven for a lot of people, especially these people have worked when the country needed, so they deserve to be rewarded. Now, once again, you said you don't need a labor certification, you don't need an I-140 approval, you don't need any employer to file the adjustment of status under this category.
Correct.
That is good provisions in these things, Emily. Emily, and what do people need to do what do people need to do to get this bill passed?
Yes, so as of this moment, again, it has passed out of the Judiciary Committee, and so it's expected to be taken up on the floor of the House next week. That means that you need to be in contact with your representative for your state, your federal representative in your location, and let them know that you support this bill and that you want this to be passed. That'll take care of the House side, which we do have. The Democrats have the majority there. This only needs to be passed by a simple majority, so the House should be covered. On the Senate side, again, we don't have the bill yet, what they're planning to include. So when you're contacting your senator, let them know that you want these provisions to be included in their version of the bill and that they need to pass the same reconciliation as the House does.
So let's go to the other issues that we have, Emily, with regards to the October visa bulletin. Obviously, we're very disappointed with the October visa bulletin because the priority dates didn't move up. The USCIS have actually wasted the 80,000 green cards. And because of that, the priority date didn't move as expected. There is still room for people to save this. There is a letter that we have drafted. The USCIS can still adjudicate these applications within the short period of time, and based within the short period of time, and they should be able to recapture that in the next year. We want all of you guys to write these letters. We want all of you guys to write these letters. When the draft of the letter has been provided at the bottom, please go there. We can still have some time to save these 80,000 green cards in this year. What is expected in the coming months for the priority dates? Now they wasted 80,000 green cards, and if things don't get across in the Congress or things get delayed, these people are tending to waste more next year, coming in October of this year.
Right, so you've probably all seen the October visa bulletin, and that EB2 date is expected to continue moving forward. The final action date should move forward several months each month going forward. But what was also a bit shocking in this visa bulletin was their note at the bottom about EB3, that it could actually retrogress in November. Which we're not expecting at all. I mean, we've been told time and again all summer through these online chats with Charlie that we shouldn't expect any kind of retrogression. We have plenty of green cards available. There's plenty of green cards available to adjudicate all of these pending adjustment of status applications that are already there. And then we're again adding more green cards from the family-based spillover from this year into next year, yet EB3 might actually retrogress. So we may get to a point where EB2 and EB3 end up being the same date.
So have we seen that EB2 and EB3 becoming the same date?
We have seen that for China from time to time. Now, those that have not dealt with the downgrade situation before, it's been very common and happening in the past with China, and the EB2 and EB3 have flip-flopped for them many times over the years, and it had gotten to a point where they evened out as well because of so much flip-flop back and forth and people upgrading and downgrading over the years.
Let's discuss about, Emily, on the changing the employer while the adjustment of status. There are two particular scenarios where the changing of the employer could occur. One is when the EAD is approved. One is when the EAD is not approved. When the EAD is not approved, what are the steps if they want to change? If the I-140 is approved and the adjustment of status is pending for more than 180 days.
Yeah, if you don't have an EAD approved yet, you need to think about this in two different processes. Number one, you need a way to work for the new company, and so that, if you're on H-1B, is going to require the new company to file an H-1B transfer since you don't have an EAD yet. The second process that you need to go through is the ACU-21 process to actually take the green card with you to the new employer. That requires your 485 should be pending for 180 days and your I-140 is approved. The new job has to be in the same or similar occupational category as the old job, and the new employer needs to submit an I-485 Supplement J confirming that the job offer qualifies. So those are going to be two separate processes that you have to go through if you do not have the EAD.
And if you have the EAD, then you just file the 485J supplement in. Emily, what do you suggest for the people whose I-140 is still not approved? They want to change the jobs, though.
Yeah, I would definitely recommend premium processing of the I-140. I know that has its difficulties right now, but it is very risky to port your green card to a new employer based on having the I-485 pending for 180 days if your I-140 is not yet approved. You have to be able to show that it was approvable when filed, which that's open question that USCIS can raise in your 485 application. So it is very risky to do that. So I would talk to your current employer about upgrading that I-140 to premium. If it gets rejected because it's a downgrade, keep submitting it. We are getting them eventually accepted. It's the time it's taking for USCIS to pull the old labor certification from the old file and move it to the new file. That's what's causing the delay, even though in my mind there's no reason for them to be doing that, and we're actively looking at a lawsuit on that exact topic.
Let's go to some of the question to answers. The question from Mano Krishnaswamy is asking question that $5,000 provision applying for 485 is used to get GC or EAD. Can you please confirm? It's for both. It's not just for EAD and AP. You will also be qualified for getting the GC. Now, the only thing is that you must have a labor and I-140 approved, and your priority date must be more than 2 years old. That is an absolute requirement for it. Question coming from another gentleman is that does working for a university, does it qualify for the critical and essential worker? At least when I see the list that is there in the 14 list that has been given, though, education has not been listed in this one, though. Although communication and information technology has been listed here, though, they haven't given the education as one of the issues in this one. So we may have to look into further details how they are going to look into it, because it's not clearly defined. The rest of the things, for example, we know what is there in the Dreamers, we know what is there in the when the extra green cards are going to fall out. We know the $5,000 green cards, how you will be qualified if you have a labor and I-140. But when it comes to the critical and essential workers, though, we may have to see if the government is going to come with any regulations which they have to come with, so that it gives a clear idea, though. At this point of time, though, by reading the law, I don't see education as one of it, at least in this one.
Amit also has a question about the essential worker option, and he wants to know, do remote workers work, or does it have to be on-site? And do you have to be exactly working from January 2020 to August 2021? All of these things are going to have to be defined after the bill passes. The only thing we know at this time is that you have to be in the U.S. January 1st, 2021, and continuously physically here since then. A consistent record of earned income in an occupation in that list, and then during the period from January 30, 2021 to August 24th, 2021. Beyond that, we have zero guidance. There's no way to know exactly how they're going to implement it. Again, I do think with the Biden administration, it would be more broad and less narrow. So hopefully more people could qualify for that. But the details we won't know until after this passes and they come up with the actual application process and maybe some regulations to implement it.
Muthu Kumar from YouTube has this question. Sorry, I have some doubts. If I send this letter to the representative, what is the guarantee that they are going to read the entire, will they ignore It is possible that they may ignore you, but you have to try. I mean, there is one theory that I say, when you are a baby, 2 days old baby or 1 day old baby, how would the mom know that the baby is hungry? The baby cries. I mean, that's how they know. And if you don't cry, or if you don't, in this case, not cry, if you don't inform, they won't know. Look at how the dreamers are doing. They know because they cry a lot, and you guys don't cry a lot. So that's exactly what I meant to say, is to write the letters. If they look into it, that's all you can do in the democratic system that we have. You can petition the Congress. You can petition to the Congress. Even you don't have to be a U.S. citizen. You don't have to be green card. You can write a letter. You should write a letter. You should have your friends write a letter. That's all you can do. We have seen in the past 3-4 weeks, we've been proposing that to write letters to the congressmen. If you look into this draft that we have provided, it came way before. Some of the provisions that we recommended were, I mean, I'm not telling that it's only because you guys wrote the letter it happened. It could be that you have written the letters. That draft was provided. We recommended in our drafts that to not to have the employment-based immigration increase. Well, technically they did, because by introducing this $5,000 provision, they increased the number of the green cards. We told that the unused green card should be provided in there, that they have used it. Legal dreamers should be provided a chance to get the green card. They have done it. So yes, Muthukumar, you have to try. After we leave the message, there are a lot of people that comment very bad on us, saying that you keep on telling us to write that nothing happens. Yeah, you have to keep on trying very many times. This is a marathon. It's not a 100-meter dash. You just write a letter. Do you think so Congressman is going to come walking to your door and then ask, hey, Mr. John Doe, Mr. Muthukumar, what do you want to have? That's not going to happen. There are many elements of there. There are some people who don't want immigration provisions at all. There are some people who want better provisions. So you need to have your voice heard. The only way that I can think about is write letters to the congressmen and the senators. The draft of it is provided. Nobody else is providing you the draft. When I speak with some people, I don't want to name them, they're not interested in this bill to pass for whatever personal reasons that they have. So I don't like them, but you need, I mean, I'm speaking about not the congressman, but the individuals though. They don't like this bill to be, they don't want you guys to get the green card. So if you want to get the green card, this is the best provision that we think is available for you right now.
And remember that because this is being done through the reconciliation process, we only need a simple majority in both the House and the Senate, which the Democrats currently have. We don't have to worry about one senator blocking the whole thing and using the filibuster and needing 60 votes to break it if we go through this budget reconciliation process.
That's the beauty of it. Normally, when an immigration bill is being presented though, it first should originate from the Senate, and that's where the problem comes in. They need 60 votes, and the 60 votes never come. We have seen the SR 386 bill or HR 1044 bill. One senator comes in, he blocks it, and then we lobby, and then another senator comes in. Each of the senator they'll keep on asking concessions. Some of the people can even ask concessions for the immigration, saying, hey, build a bridge from one area to another area in our constituency, I'm going to approve it. I mean, that has nothing to do with immigration. But this provision is quite different. It doesn't require 60 votes. The good part, I believe, more than this, Emily, is that right now, after this is passed in the Senate, in the House Judiciary Committee, it's not appearing on any headlines anywhere. Any headlines anywhere. It's not there. Fox News, CNN, ABC, it's not appearing anywhere. In any of the major newspapers, it's not appearing, which is actually good. Their topic is more on the $3.5 trillion bill, which this bill is contained in. They're concerned about Afghanistan, they're concerned about other things, but they're not, this doesn't even come in the top 20 news of the Fox News. At least I didn't see, I just checked it right now. Maybe it will come tomorrow, day after tomorrow. It's not appearing anywhere. So the $3.5 trillion bill definitely is appearing everywhere, which this is a part of it. We may not have much discussions. I mean, this provisions came in on a Saturday, Emily, and it was released on September...
Friday night.
Friday night it was released on, and today is Tuesday.
And they voted on it
last night,
11 o'clock.
So it's done. I mean, not much discussion, not much there. So we just suggest you to keep writing letters. This is the best ever we got it. We have to keep writing. That's all I would advise Muthukumar and anybody else. Please keep writing letters.
Sushil from YouTube got his H-1B cap case approved last week, and then this week got the H-4 EAD approved, and wants to know if there's going to be a conflict between the H-4 EAD and the H-1B status. So remember, your H-1B cap subject petition start date is not until October 1st. So it has not actually taken effect yet. So your H-4 covers you from now until September 30th. On October 1st, your H-1B can kick in, even though the dates of the approval are reversed. Now, if it happened after October 1st and you got your H-1B approved and then your H-4 approved, that can be problematic, and you may have to use automatic revalidation to travel and re-enter in the status that you want to be in to clear up any doubt about what status you're in.
Questions coming with regards to the critical essential workers. Does working for Cigna 8 now as a software qualify as essential worker? Yeah, it could be. Because it says healthcare definitely is listed in there, it could be. The question that comes from, is teacher qualified for the essential and critical essential worker? Deep in my heart, I definitely believe, but when I look into the list that's there here, surprisingly, it's not listed in there. I mean, they have listed financial services, they have listed energy, they have listed information, communication information technology, but not the teaching profession. That's shame, but anyway, if you're not qualified as essential worker, you may want to look into filing a labor certification, and 2 years down the line, you are in line to file the adjustment of status by paying the $5,000. Emily, is this $5,000 for a family or for a person?
Seems to be for the whole family.
So whole family combinedly won $5,000. I saw some $50,000 filing fees too. Is that true?
Yeah, that's there. If you are an EB-5 investor and you are investing $1 million to receive your green card, then you have to pay $50,000 to get your green card in under this provision.
Why is the money essential for this bill, Emily?
Yeah, that's the great part of the way the Democrats did this and tied it into the budget bill. They're using these fees to explain how this is carrying out the budget that the Senate agreed on, the $3.5 trillion. So we have to have money in this bill in order for it to actually tie into the budget.
Kaushik has this question. We're noticing messages that this this employment section is not there in the Senate version. Any information to this regard? At this point of time, we don't have any draft of the Senate version, Kaushik. You may be right. That's exactly why we want you to write the letter that we have put out there, because we need you guys to address the issue with the senators. Please write that letter that is given there so that we get the employment-based immigration issues though. The Senate version, it's not released, but I can assure you that there is a provision for the dreamers, the children who came when they are at young age and they are not in legally, they don't have a legal documentation in the United States. They are in there. I mean, we for sure can tell that, even without looking into the draft of it. But for us, our provisions to come in, we need to write letters. Please keep writing letters until the bill is passed, until the president signs a bill, keep writing the letter. So please, this is just a start right now, but we don't have much time. When would this bill be passed, Emily? When would this bill should be passed though?
Yeah, we ultimately would like to see this passed before the end of the fiscal year, September 30th. So we're going to be coming down to the wire.
So it's important. These 15 days or 12 days are important. please keep writing letters to the senators and the congressmen of your area to get their attention on the employment-based.
John Jay from YouTube has a good question. He wants to know what will happen to the rest of the world applicants. Will there be any effect on them? Or is the country quota totally removed? It's a really good point, because that was one of the sticking points of prior bills, the fairness for high-skilled workers. You know, when you remove that per country cap, people were worried that now people from other countries are going to get edged out and only Indians and Chinese are going to be using up all the green cards. Well, this solves that, because it's not taking green cards away from the rest of the world. The rest of the world is also getting all of those recaptured green cards. The rest of the world has more green cards than they're ever going to need. And the way that the 2-year rule works, it's just exempting those that have a priority date 2 years old from the per country limits and from the quota altogether. So they're not using any green cards that currently exist. They're not even counted at all. So it has zero impact on the rest of the world.
Akash Mehta is asking, where is the letter you referred to be sent to the lawmakers? It's there, please, at the link that is on the Facebook and YouTube, guys. There is a link for you to go to RN Law Group. In the news section, there is a draft letter. There's a provision how to reach your congressman, how to reach your local congressman, and the draft of the letter is there. The question that comes from Raish Ansari from YouTube. Does the bill has to be passed by September 30th? Can you hear it go beyond that? Good question. It can go beyond that. It doesn't have to be essentially passed before September 30th. The administration would like to pass this one before September 30th. Yes, Mr. Ansari, I remember that last time when we faced in the deadline for the Senate 386 bill, ping-ponging here and there, we were so crucial, and then boom, the Congress goes out of business. And the whole bill came dead, and we have to start all over again. No, this Congress is going to be there for the next 1 year and 4 months, or 3 months, just at least for the next 14 months, this Congress is going to be there, so they could still be passed by the time. But obviously, Mr. Raish, you, me, and this administration would like to get it passed before September 30th. There are other requirements, nothing to do with the immigration, though, that may require some extensions. They may block some things because of funding problems. But as far as this bill, there is no absolute essential that it has to be passed by September 30th, though. Question from Hari. My prior date is November 2018. Am I qualified for the $5,000 to pay for my green card? Well, before I answer the question, though, remember, Mr. Harishankar, if this bill passes through, we're going to get extra 300,000 green cards, though. You may not need to pay the $5,000 extra. But if I go, my calculation goes wrong and everything, you may have to pay $5,000 extra to qualify for the green card, though. One other thing, whether it's a good news or a bad news, Emily has pointed out, but I just want to point out that on top of the regular 485 fees, which is $1,225, it seems that each applicant have to pay extra $1,500 filing fees. So the filing fees will go up from $1,225 to $1,500 extra filing fees. Remember, Emily was pointing out this is a budget bill. They're trying to get the money from us. So for one person, if the filing fees is right now $1,225, it's going to be $2,000. It's going to be about $2,800 if the priority date is current. If the priority date is not current, then you add $5,000. That's approximately $7,800 for the main applicant. When it comes to the dependent, though, definitely the $5,000 is not there. The 1225 is always there for the spouse. You have to pay extra 1,225 in the normal filing fees. You may even end up paying that extra 1,500 for your spouse also. It's not clear, but based on how I look into it, you may end up paying extra fees. So remember that this is a money. The Congress likes the money. The administration likes the money. And most of the people, to get rid of the immigration lawyers, I know you will pay the money. And I advocate this bill to go through, because you don't want to be an H-1B for a long period of time. It's very costly, guys. It's very painful. I've been in that status. I understand that. I got my law license. I was a lawyer, but I couldn't work because I don't have a work permit at that point of time. It was really frustrating. I was on the H-4 visa. I used to go volunteer in some legal aid societies until I got my EAD. So definitely a lot of people will be in the situation. This is a thing that helps who are aging out. This helps for the spouses. Every time H-1B has to be extended, every time you go outside the country, you have to get the stamping. There are all those things you can eliminate by paying this extra money. On behalf of understanding what you guys are, I believe that it's worth for us to pay that extra money to get rid of the hackles and get the green card. That's my belief. So per family, this may increase the filing fees to approximately about $8,000 if your priority date doesn't become current. Per family, this will definitely increase per family $3,000 if the priority date becomes current, which is extra 300,000 green cards should push the priority date way in advance.
Parag from Facebook has an approved I-140 with his previous employer and wants to know how long can we use that to transfer or extend the visa with a new employer? What if the new employer is not initiating the green card process? Can we use that old employer's I-140 approval to transfer or extend? So assuming that you stayed with that company for 180 days after the I-140 has been approved, you can use the old employer's I-140 approval to extend your H-1B status for 3 years at a time with any employer, the same employer or a new one, or even another one after that, even if the new employer has not started the green card process. However, that cuts off when the priority date of that I-140 actually becomes current. So if your date is becoming current soon, you need to have the new labor certification and new I-140 in place so that you can file the adjustment of status.
Rajesh, very good questions. Can this bill be restricted? Can this bill be blocked? Yes, it is a chance. There is a chance for it that it will be blocked. There is a chance that it will be restricted. There are some times, as we call it, as a poison pill. Bill looks everything good, but they will add some extra provision that your prior date must have been 2010. Or something like that. I mean, they can add some crazy things into this we call it as a poison pill. We need to be watchful because there's a lot of things going on right now. Luckily though, the focus doesn't look to be more on the business immigration. As of now, when the bill is being proposed in the House Judiciary Committee, when it passed, though, nothing changed, which is absolutely very good. We hope the same thing will happen, but you need to understand, Rice, that you need to do your effort to contact the congressman.
Manjeet wants to know, with this new provision to file the green card by paying $5,000, should we be working for the company that has the approved I-140, or it doesn't matter? So again, the whole basis of the green card for employment is based on an offer of employment. So that offer still has to be there. The employer that sponsored your I-140 still has to be willing to sign that supplement J to allow you to file the 485. So none of that is changing, but you don't necessarily have to be working for that company at the time of filing the 485.
Muthu Kumar has this question. I wrote the letter. My representative is a Republican. Does it work? Yes, it does work. You'll be very surprised, though. Not all Republicans may be against this bill. Even if they are against this bill, they may soften it. They may understand it a little bit on this one. If you look into the bill that was passed in October 17th of 2000, though, that's approximately around 21 years ago. It's called American Competitiveness in the 21st Century. This bill was passed by overwhelming majority, and this allowed people to extend the H-1Bs beyond 6 years. This allowed people who are in adjustment of status to change the company from A to B after 180 days. This allowed people to change from company A to company B on H-1B by filing an H-1B instead of getting the H-1B approval. There are a lot of provisions that this bill allowed. This bill was passed in 2000. This is one of the, this is a major legislation bill that I've seen passed in the past 25 years that I've been. When this bill was passed, it was Senator Abraham, who was a Republican from Michigan. He was a Republican, and when I looked into the co-sponsors of the 24 co-sponsors from the Senate, though, 18 of them are Republicans, though. This bill was passed with 96 votes to nothing on the opposition side in the Senate. So just because the person is a Republican or a Democrat, it's not our duty, Muthukumar. You can't control it. You can't vote the person, though. I would advise that it doesn't matter whether the person is a Republican or Democrat. You should write the letter to them, irrespective of. You should write the letter to them.
Gauri Sanker wants to know, can I use an older priority date for this, or does it have to be the latest I-140 that has to be only 2 years old? So the way that it's written, it is based on, you have to have an approved I-140 petition, and you have to have a priority date that is at least 2 years old. So with the current law that allows you to retain the priority date from an old I-140 and apply it to a new I-140, you should be able to use your earliest priority date to meet that 2-year requirement, as long as you had that I-140 approved and you've retained that date with your new I-140 approval.
Is it a good idea to change the employer right now when the priority date is 2019? Mr. MK, I may want to wait. That's what I would do. Pradeep Sharon, does physical therapist qualify for essential workers? I think so. We can clearly say yes, Emily, right?
I think so.
Yeah, that's going to be very hard to take the physical therapist out. There are a couple of things that favors the physical therapist. One is that you might have physically worked from January 1st of 2020 to August 24th of 2021, and you probably went to the clinic to work. I mean, you went to the place physically. I mean, some of the people work remotely. That may be a minus point for them, but you have went physically to work, because I know my wife is a physical therapist, so I know, you know, she worked in that period of time. So I would be very, very surprised if you will not be qualified as an essential worker.
A couple of questions on the EB3 retrogression that's coming. What would be the impact on pending downgrade applications? So the I-140 would still continue to be processed if that's already approved and you've already filed your 485. The 485 will just be kept on hold until EB3 final action date becomes current again for you, and then they can complete the process. And then another question, will CESPA still apply if the I-140 is approved and the date gets retrogressed? So that's the Child Status Protection Act. So if your I-140 is approved and your final action date was current and you filed the 485 and your child was under 21 at that time based on their real age or their CESPA age, their age is locked in even if the priority date later retrogresses after that 485 has been filed.
It's only the one day that you need to be there. The I-140 needs to be approved, 485 has to be filed, final action date has to be current, under 21, that's it. The child is locked. That, later on, if the priority date goes back, that's fine, no problem with it. The child never ages. It's like a miracle. The child never ages. I wish I never aged.
It's the fountain of youth.
The fountain of youth. We call it like that's the Amrut. That day on which you have the I-140 approval, you have the priority date current, you file the 485, and child is under 21, you got the Amrut, that's it, you never age.
Another question on aging out. What if the child entered when they were 18, but left to go back and get the F1 later and came back? Been here since 2016, except leaving in between. So if they entered before 18 has 3 years of residence in the U.S. and was here on January 1st, 2021 and has not left should qualify under
But
that
did you
Dreamer
say, did you
provision.
say the kid left for the
I
student
think it
visa?
depends on how long they left for.
Here is the reading that's I see, Emily, is that when I release a close reading of the bill, though, you must be continuously physical presence from January 1st of 2021.
Right.
That means that any time you left out.
No, he left before that.
Oh, he left before.
Yeah.
Okay. Oh, thank you. I just want to make sure. So you must be continuously present here from January 1st of 2021 to all the way that your benefit has been. If you left before briefly, though, that's okay. It's just you have to be physically, you have to have a residence in United States for past 3 years. If you have left before January 1st and came back, yeah, that kid is still qualified according to me, yes. Sorry.
Another question, what happens with the applications who filed last October if the budget reconciliation is passed and our applications are still pending? Well, because we have the recapture of about 300,000 green cards and those won't go to waste, I would hope that yours would be covered in that, and so your application would just be processed. Your final action date would remain current. We just have to wait for USCIS to finally get around processing the application, so it should not be impacted negatively.
Teja has this question, people working for Uber, Lyft, DoorDash, or any other considered as essential worker? That looks to be very tough for me. That looks to be very tough for me to be qualified as an essential worker, but we'll have to see how the regulations are going to be promulgated and see if there is anything that will be allowed for them.
Ram Kumar asks, so anyone with an August 2020 priority date can apply for AOS in August 2022?
Yeah,
that's exactly
absolutely
right.
That's exactly right. That's a good question that he asked, Emily. Is it only the people who are qualified on that day, or is it the people who are qualified later on also can file?
It keeps going. So in June, if you filed in June 2020, then you can apply in June 2022.
What about I filed in January of 2021, Emily?
Yes, you can still get it in 2023.
2023.
But this does only last for 10 years. I want to point that out.
I missed that point.
Because this is a 10-year budget. So this is not a long-term fix. So this particular provision does expire in 10 years. So we still have more work to do on other reforms later, such as removing the per country cap, because this doesn't do that, and we will be going back to the old ways 10 years from now. But for those that are here now, you should benefit from this.
If I qualify, Sandeep has this question, essential, should I not leave the US and not go vacation to India? Is this correct? Yeah, I would wait to see what's going to happen on this one. I would not leave the opportunity that comes in. I would not even say it's once a decade. It looks to be like once in a lifetime, at least in my lifetime. You're still young, though. You may get some more of these things, but I don't know. It's never seen that. I've heard this kind of bill, Emily. The only thing that I heard that when I started practicing, though, it was the amnesty bill that passed in 1985. After 1985, the only bill I know is the IRA bill, which is more restrictive, and this AC 21 bill that came out in October of 2020. Any questions on? A question with regards to Senator Durbin's language. We will have a lot of people come into the picture discussing about the immigration bill, but Senator Durbin may be busy in a lot of other things. So believe me that this is a $3.5 trillion bill, though. Their focuses may be on other things too. Sometimes people have to give up something to get something. So and he may be giving up on this one because he belongs to the Democratic Party. So there's a good chance that he may not be putting a hold on this one.
Prabhu has a priority date in September 2018, but has changed employers in the last few months. Wants to know, do I need to port my I-140 to the new employer before I become eligible? Yes, you would need to have the new labor certification, new I-140 approved, and port that priority date before you can file under this provision.
This gentleman, Siddharth Razdan, I work at Pfizer on vaccine projects and was working on site during COVID. Will I be eligible for essential worker green card? I mean, if you meet the dates requirement of presence in this country on January 1st of 2021, and you meet the other requirement, just the dates requirement though. As far as your job requirement is concerned though, I mean, if you are not qualified, I can't believe of any other person who could be qualified under this essential work. Just the dates are important for you, that you never left the country after January 1st of 2021 and have worked from between January 1st of 2020 to August 24th of 2021. If you meet these two requirements, I cannot understand how you cannot be qualified for the essential worker, because you work for the Pfizer and for the medicine, and you worked in the COVID period. You definitely should be.
Ram wants to know if being out of the country for a month on vacation defeats this continuous stay in the U.S. from January 2021. Yes, the bill is very clear. It must be continuous physical presence from January 1st, 2021. If you've left after January 1st, 2021, you would not qualify for those particular provisions.
Rajani has this question. They already filed their adjustment of status. Do they still need to pay $5,000? Most probably your priority date is going to be current naturally, even if it's backtracked, it will become because of the extra 300,000 green cards we're going to get it. So I don't see any reason whatsoever at all for you to pay the extra $5,000. A question. Oh, this guy has very good question. Don't worry, folks. USCIS will take 20 years to process if this bill passes, and bill will expire. One thing, Sriram, is that there's a lot of money involved in this one. We're speaking about a family, typical family, at a minimum of $3,000 extra fees to about $8,000 for a family of 2 people extra fees. Now, on top of that, there is a provision. How many billions of dollars are allocated?
$2.8 billion for USCIS specifically to reduce processing times.
So please keep the hopes up, guys. Keep writing the letters. That's all we can do. I mean, try to do it. This bill is very good. I suggest that don't keep on saying nay, nay, nay. There are things that will come up. This administration, though I have a lot of criticism how they handled the 485 application, is far, far better than the previous administration. The way the H-1B denials were being, the way things were handled, the way things, every time we have to go to court, things are much different here. Now, we did see a lot of delays, though, but at least the denials are very less compared to the previous administration. Anything else, Emily?
I think we're about out of time for today. Thank you so much for joining us. Be sure to write your letters. Please contact your senator, contact your congressman, have your friends do it as well, your coworkers, so we can get this passed with these provisions as is.
Thank you.